please understand that when I answer your question, even if it's the particular facts that you submitted, I'm not intending to give legal advice in the webinar. The information I provide here should be considered general information relating to things that landlords need to know. And some of the questions were outside of the landlord-tenant realm, but I'm still going to answer them. But when I do a one-on-one consultation, I ask a lot of questions and I require a lot more information in order to make sure that my answer is correct and accurate. So I'm taking the general facts that have been given and I may be assuming some things and adding some things. So just take it with a grain of salt that if you do need to take legal action, you should come and talk to me one-on-one and make sure that I have all the information that I need. And so let's get started. All right, still learning how to use this Canva slide thing, so forgive me for a little bit of delay. So the first subject matter is tenant and HOA issues. The question that was submitted is that as a home provider, aka a landlady, at an HOA, the property's in an HOA, the tenant would like to install a mesh screen to keep the bugs out. We currently have the approved security screen, so the property has an approved security screen approved by the HOA. However, it's not the type that keeps bugs out. Other units have installed those mesh Velcro screens and they are being fined for not removing them. Or they removed it after requesting to be allowed to keep it for health reasons. And I guess that request was denied and that is why they ended up having to remove it. I love those mesh Velcro screens. I have one and it's so nice. So I completely understand why somebody would like to have one of those. So the question is the HOA board of directors allowed to disregard a health or safety request regardless of whether the requester is disabled? So the HOA is considered a residential housing provider under the housing laws. And so HOAs do have to be aware of requests for reasonable accommodation for people who are disabled. They're also not allowed to discriminate against other protected classes such as religion, ethnicity, race, military status, a variety of other protected classes in California and in the United States. So the HOA is not allowed to disregard a request for a reasonable accommodation by somebody who has a disability. But in HOA relationships with tenants, there is not a direct relationship. So the HOA's responsibilities run through the member of the HOA. The member of the HOA is the property owner, and then the owner has a contractual relationship with the tenant. So when the HOA tries to regulate a tenant or respond to a tenant's request, the request has to go through the owner, or the fines or the discipline has to go through the owner. The tenant should be kept informed by the HOA because notices should be delivered not only to the owner, who obviously would live elsewhere if they're renting the property out, but the tenant should also be receiving a copy of any notices. Now, another issue that comes up here is that an HOA is a private accommodation, but many of the laws requiring reasonable accommodations, like the ADA and the Unruh Civil Rights Act, may only apply to public accommodations. So depending on the circumstances of the common areas and the roads, if the accommodation has something to do with parking or curb ramps, those sorts of things, you get into a dispute with the HOA, a factual dispute about whether the HOA's common areas are a public accommodation or a private accommodation. And so, I was just in the middle of resolving some litigation relating to those kind of issues. The landlord has the obligation to make reasonable accommodations as well for the portion of the property that the landlord is in charge of, which is the interior of the property. And then with this screen issue, the screen is kind of on the threshold between the landlord's responsibility and the HOA's responsibility. So we would look carefully at what the CCNRs say about, whether the HOA is allowed to regulate the doors and the screens and those sorts of things. So after we review all of these issues, another thing to be aware of is, as a private accommodation, the landlord is a private housing provider, and the interior of the residential property is a private accommodation. The law says that a private housing provider in a private accommodation is not required to make structural modifications to the property. In these situations, if the tenant offers to make the structural modification that they need, they may do it at their own expense, and the landlord may be required to approve the structural alterations that the tenant is going to make, as long as it's reasonable. But the landlord is not necessarily required to incur the expense of the accommodation. There are some other exceptions, and this area of law is really interesting because you get into all of these questions. Another exception might be if the HOA on the exterior, even if it's a private accommodation, has to do some substantial alterations to other things. They may have to bring the community, the communal areas up to code. And those code requirements may require things like building code regulations that are in compliance with the ADA and other kinds of accommodations. So it's a very interesting question. And when we're talking about just this screen, I think that would be a situation where the landlord would want to support the tenant, especially if it is a disability issue, if it is a serious health concern. The landlord would want to support the tenant in making the request to the HOA, because the tenant would usually not be able to be recognized when asking those for that sort of accommodation from the HOA. All right. So long story short, we'd have to look at the facts before we can decide what the HOA should do. And the end of that question was regardless of whether the requester is disabled. So I'll get into this, I think, a little bit later, but how would a landlord know if the tenant is disabled? Unless the tenant tells them outright, a landlord's questioning a tenant about their disability could cross a line into their privacy and and maybe even trigger the idea that the landlord might be discriminating by trying to find out specifically what the disability is. But a landlord is entitled to enter into a communication about whether the person is disabled. They can request documentation. They're not entitled to the details of the disability, but they are entitled to some evidence, like a doctor's letter stating that the requested accommodation is necessary to accommodate the disability. So there are different ways that we handle that depending on the circumstances. So tenant improvements and reasonable accommodations, I kind of already went through most of what I have on this. Another question was, how do you determine whether the accommodation is based on a disability? So that's what I was just mentioning. You would want to engage in a conversation with the tenant about what is needed for the accommodation, and then the landlord may request documentation that says only that the doctor recommends this accommodation for the tenant's disability. They're not entitled to know why or what the disability is, unless the tenant chooses to share it, of course. The landlord's obligations here are things like allowing something reasonable, such as an emotional support animal. Emotional support animals are, as long as they aren't dangerous or inappropriate for the nature of the property, may be reasonable. And when we get requests relating to emotional support animals or ESAs, I have some materials that I like to send out, and I could send those out as a freebie with this. You know, I like to send something out after the webinar. So when considering whether to provide the ESA, we get tenants, the landlords provide us with documentation that the tenant provides that show that the animal is a certified ESA. And these are things that, you know, people get online, or they have their animal trained and they get their animal certified somehow. But that's not what the landlord needs. The landlord is not looking at the animal, the landlord is looking at the need of the tenant and needs the justification from the tenant that the tenant requires the accommodation of the ESA. So allowing the tenant to make certain alterations at their own expense, if there's structural modifications, that is okay if the tenant's offering to do that. And just to reiterate that the HOA's authority to regulate tenants runs through the landlord. So the landlord may be fined for things that the tenant is doing. If the tenant puts up a screen and refuses to take it down, the HOA takes action against the landlord. The landlord can charge that back to the tenant. If the landlord has engaged in this conversation with the tenant and determined that the screen has to come down, and they've supported the tenant through requesting a reasonable accommodation, or they've determined that they don't have to do a reasonable accommodation because the tenant does not have a disability that requires the screen, then the landlord can pass the expense of the fine back to the tenant as a violation of the lease. Okay, so let's go to the next question. Next question also involves HOAs. I kind of lumped some of the questions together because they had similar subject matter. The next question relates to HOAs. Regarding HOAs, how should property owners engage an HOA who doesn't enforce most of their own rules and regulations, but aggressively enforces selected rules? For example, there's no enforcement of parking, trash, lighting, landscaping, exterior condition violations that are in place to maintain the community quality and property values. But if an owner wanted to lease a property out for less than 30 days, they would face steep fines as a penalty and swift enforcement. So I see a couple of issues here. One is fair enforcement. Another is the board members' fiduciary obligations. And then we'll go into the next slide, which will be the issue of the short-term rentals and restrictions on rentals. So fair enforcement is important here. An HOA cannot act arbitrarily or capriciously. They have to enforce the rules equally among all of the members of the HOA, not only to avoid claims of discrimination and retaliation, but also because the law says that they have to have a good reason for everything they do. It can't be arbitrary, it can't be capricious, and they have to follow the governing documents. So fairness is really important here. And if there are rules in place under the CC&Rs and rules and regulations, the HOA has a fiduciary obligation to all of the homeowners to enforce those rules. For instance, if they're not enforcing parking rules because, hey, board members are volunteers, you don't want a bunch of members of the HOA given the power to enforce parking restrictions. You just want, and those board members certainly don't want to get involved with every parking dispute. So you want to fund the HOA and make sure that the HOA is charging enough money to hire parking enforcement services. If you're going to enforce the parking on your own as board members, I think that is a huge obligation for volunteers to do if you're not being paid for that. So you'd want a property management company that has some sort of parking enforcement, or hire a separate parking enforcement company. That fiduciary obligation can fall back on the board members themselves if they are in breach. They are, for the most part, the board members are immune from a lot of liability, but the HOA can end up getting sued or having to go to mediation and resolve disputes for things that harm the members of the HOA. So active participation of the members of the HOA, open communication. This is how we make sure that the HOA stays on the up and up and enforces the rules and everybody stays happy, hopefully. So power to restrict rentals by an HOA. This is a really interesting issue, and I write an article every other month for the Real Producers magazine. So my recent article in there was all about this issue. So I thought I would give you guys some of that information. So the restrictions of an HOA must be reasonable in order to be enforceable. So an HOA cannot issue a blanket restriction on all properties that they cannot rent them out. That is not reasonable. They can't prevent everyone from renting out the properties based on certain restrictions. However, they can require that all the properties can only be used for residential purposes. So they can exclude any kind of commercial rentals, and they can exclude any kind of commercial uses. What comes to mind that probably would not be reasonable is if they restrict people from working from home. That is not usually considered a commercial use. And I think that, as an example, that would probably be an unreasonable restriction, but they can prevent you from advertising a commercial business from your home. Okay, so they can, however, case law in California has held that they can require rentals to be a minimum of 30 days, thus restricting short-term vacation rentals. They can also require written leases that state that the tenant agrees to comply with the conditions, covenants, and restrictions, any rules and regulations and notices from the HOA. They can require that a landlord provides a copy of all of those governing documents to the tenants, and an HOA is free to decide how it wants to regulate, but any extreme restrictions may be tested by a court of law. So minimum 30-day rentals, written leases, those are all okay, based on California case law. There's also a civil code statute, section 4740, that limits the HOA's ability to impose rental restrictions retroactively. So the statute would ensure that homeowners retain the rental and leasing rights that they had at the time of purchase. So any rental restrictions that are adopted by the HOA after a homeowner acquires their property cannot be applied to the homeowner unless the homeowner voluntarily agrees to waive their pre-existing rights. So a waiver would look like a written agreement where the homeowner signs off that they waive their pre-existing rights and they accept the new regulations. So of course, changing HOA restrictions can be really difficult. A lot of those changes require a substantial vote of a majority of the members or even a supermajority of the members of the HOA. Those are some issues that have come up, very difficult to navigate. Right. So then HOA discrimination and owner's rights. We already covered some of this, but just to reiterate. So the question was, are HOAs, this is another question, sorry. Are HOAs allowed to fine or deny an owner's request for painting the front door a color of their preference based on religious beliefs? So the issue here is whether such a restriction would be subject to a claim of discrimination, whether it's a violation of fair housing laws or other kinds of anti-discrimination laws. the HOA is considered a housing provider under housing laws, both federal and state, and cannot discriminate against a protected class. So a religious class is one of the protected classes: race, ethnicity, gender, marital status, family size, military status. There are a whole bunch of them. But the challenge with these claims is, in order for it to be, so there's an administrative arm to discrimination enforcement, and then there's civil court. At our office, we file lawsuits in civil court, but we also represent property owners who, in particular, we have property owners whose tenants file civil rights department complaints against them. So what used to be the Department of Fair Employment and Housing is now the California Civil Rights Department, and tenants file a complaint with this administrative body, and then the landlord has to respond to a bunch of questions and potentially go to mediation. And if the Civil Rights Department finds a violation, then they can take some action to discipline the landlord. And if they get through this process and the complainant does not like the result, the complainant then has the right to file a lawsuit against the landlord. But the challenge with filing a lawsuit against the landlord is that the complainant has to prove harm. Under the Civil Rights Department, on the administrative side, the harm does not necessarily need to be proven the way that it does in a court of law. The harm could be just proving that discrimination occurred. But in civil court, you generally have to prove, you have a higher burden to prove that discrimination occurred, and it was directly related to the protected class and that it caused harm. For a housing provider, such as an HOA, generally the claimant is trying to provide proof that the HOA prevented them equal access to facilities and resources. So they were harmed by not having access to the pool or access to walk around the HOA the same way that everybody else does because they have a disability, things like that. This particular question about painting the front door a color of their preference, I haven't had a lot of time to research this. I apologize. But I would suspect that this is not a violation because the color of your front door does not restrict you from accessing the facilities and resource of the HOA. Even though it may be apparently discriminatory, and maybe if you have other evidence that the HOA has taken other action to make the person feel uncomfortable, to make them feel discriminated against, that may be something actionable under the Administrative Civil Rights Department. But in civil court, it would be a harder case to prove unless there was some sort of a restriction from facilities and resources and some kind of overt discrimination, proof of discrimination. All right, so then buyer and seller scenario. So this is interesting. So the question is, how can a buyer pursue recourse against a seller that backed out of a purchase and sale agreement on the funding day with no probable cause? And how can the buyer force the transaction to go through if the buyer has shown their willingness and has performed every step of the transaction? So this is not a landlord-tenant issue, but it is an interesting issue, and we do handle these kind of cases. So buyer-seller contract disputes, such as this one, would be an action for specific performance. So what happens is you go through transactions. So the first thing I would do in a case like this is I would look carefully at the contract and see what provisions there are for termination. If we have things like contingencies that need to be removed before the parties lose their right to terminate the contract, or whether there are timeframes in which the contingencies are automatically removed by default. So if a buyer comes to us and says, I have the right to purchase this property, and we look at the contract and we say, oh yeah, that seller didn't have the right to cancel that contract when they did, then we would file an action for specific performance. Now, if you are familiar with purchase and sale agreements, such as the California Association of Realtors form, many of these agreements have mediation provisions where prior to filing a lawsuit, you agree that you will demand mediation and make a reasonable effort to take the case to mediation before you file a lawsuit. And if you don't, then many of these provisions are tied to the party's right to get attorney's fees if they win their case. So if you fail to do a reasonable job of trying to mediate prior to filing the lawsuit, then you might lose your right to attorney's fees when you win. But actions for specific performance are an exception. So you are entitled to file an action for specific performance, and then you can place a notice called a lis pendens against the property to prevent the seller from selling it to anybody else while you're pursuing your lawsuit. And then it also says in the most recent version of the CAR form that you agree to make an effort to stay the litigation and take no action in the litigation until you make that reasonable effort to mediate. So these actions are very effective because essentially the seller can't sell the property to anybody else because your lis pendens clouds the title. They can still transfer the property, but it would not be a bona fide purchaser. The lis pendens is a public record that puts everyone on constructive notice, if not actual notice, that somebody else has a claim to title of that property. So that's the legal remedy for this circumstance. If you're a buyer and you feel like you've done everything right and your seller didn't have the right to cancel, then you can come and talk to us and we'll see if we can file specific performance and put a lis pendens on the property to help you purchase the property. And the reason that you get that special remedy, the lis pendens, and the specific performance is because real estate is considered to be unique. It's not just dollars and cents. It is a unique parcel of property that you cannot find anywhere else. And so you do have the right to this specific performance remedy. Those are fun cases. We love those. Definitely send those over to us. All right. So the next question is, my tenant has lived in the rental house more than 22 years. So this is a very long-term tenancy. This tenant has never allowed me to access the inside of the house. Uh-oh. When I hear that, I say, uh-oh. I do not want to rent the house anymore. At present, it is a month-to-month tenancy with no lease. Uh-oh. It is a single-family residence, i.e. a house. Okay. A lot of uh-ohs in this scenario. I like this one because these are problems that we like to solve. So the first question about this scenario is, does the landlord need to pay 2 months rent as relocation assistance when terminating the tenancy? My question is, where is this property located? Obviously, it's in California if you're asking me about it, because I only practice in California. But is it in the city of San Diego? Is it outside of the city of San Diego? Is there any other local area that it might be in that has tenant regulations that we need to comply with? If there is no lease, which I know what people mean when they say that, okay? If you say there's no lease, that means you don't have a written lease. If you have a tenant, you have a rental agreement or a lease. It's just not in writing. You have the terms of the tenancy. So if you have no written lease, then I'm going to assume that you are not in compliance with the California Tenant Protection Act or any of these local restrictions. And so before we can take action, and let's use the city of San Diego, which is probably the most restrictive as an example. If you try to issue any notices to your tenant and you're not in compliance with the City of San Diego Tenant Protection Ordinance, then your notices are invalid. And we cannot proceed with an eviction based on those notices because when you gave the notices, your lease was not in compliance with the law. Now, the Tenant Protection Act does not have the same restriction, but if it's a single family residence, meaning there are no other rental units on the premises, or there might be another unit, but it's owner occupied, then we would recommend giving the tenant notice, a 30-day notice of change in terms of tenancy, because you said this was month to month. So we can change the terms of tenancy under Civil Code Section 827 by giving a 30-day notice of change. So we will give a 30-day notice of change to claim the exemption from the California Tenant Protection Act. And if we're in the city of San Diego, we also claim exemption from the city of San Diego and issue the city's tenant handbook, do all the things that we need to do to claim those exemptions and bring the lease into compliance. Once we claim the exemption, then no relocation assistance is needed. So you might save money by not having to pay that relocation assistance. You also make your chances of winning an eviction, if you have to file one, much better if your lease is in compliance. So that's the first thing that we do. And I would say 80 to 90% of the landlords who walk in our door for the first time, their leases are not in compliance. Okay, so then further, this is the rest of their question. Further, I will tell the tenant that I need to update and remodel my house since the house is 26 years old. So the claiming the exemption also takes the property outside of any need for just cause to terminate the tenancy. However, we still recommend using a just cause to terminate the tenancy. So updating or remodeling a house may be a sufficient just cause. All of the tenant protection laws were updated a couple years ago to include additional requirements, to comply with certain just causes. So a substantial remodel may be a just cause, but you have to go and get the permits. It has to require permits. You have to go get the permits, and the work has to be substantial enough that the tenant cannot live in the premises for at least 30 days. The exception to getting the permits is if your project is to remove hazardous substances from the property. That does not require permits, but the removal has to take at least 30 days. If it doesn't take at least 30 days, then it's the landlord's obligation to rehouse the tenant while the substantial remodel is going on. So if you want to use that as your basis for terminating the tenancy, if you're not exempt from tenant protection laws, you have to jump through all these hoops. If you are exempt, we would still recommend using the substantial remodel or some other good cause, but you don't necessarily have to jump through all the hoops. Okay, I think that's it for that one. How are we doing on time? We got about 20 more minutes, and I've got a few more questions here. The next question. My tenant in Lemon Grove of over 5 years has always paid his rent on time. He's fallen on some hard times, including a divorce. He gave me 30 days notice that he was vacating via text on November 12th. I told him his deposit cannot be used as his last month of rent payment, but he still did not pay his November rent. He tells me he will move out by the end of this month. I've been patient with him and not wanting to take legal action, but now I'm losing my patience because he has not kept open lines of communication to update me in almost a week. Do you recommend a 3-day notice? So going back to the prior example, the first thing we do is figure out where the property is located and whether the lease is in compliance. Yes, of course, if the tenant hasn't paid rent, you should immediately, as soon as the rent is past due, meaning the day after the last date in that window of payment, you should issue a 3-day notice to pay. But if your lease is not in compliance, that notice may be unenforceable. So when you come in to evict that tenant, you're ready to file your eviction lawsuit. If we go through everything and we analyze it and we decide you're not in compliance, we need to bring you into compliance, then we have to start all over. So yes, you may issue the 3-day notice to pay, and you should, because you want to notify the tenant that you're not going to let them slide. But if you want to do it appropriately, you should come in and see us first and make sure that it will be enforceable. The next question is, if yes, what are the new laws that serve a 3-day notice? On the one hand, we have the laws that apply to non-exempt properties, meaning that, if you're subject to the Tenant Protection Act and the City of San Diego or City of Chula Vista or City of Imperial Beach or all those local ordinances, if you're not exempt, then you do 2 notices, notice to pay and then a separate notice to quit. You have to separate them now. Even if you are exempt, we still recommend separating them. Just to be clear, there are reasons why they want them separated, but you don't have to separate them if you're exempt from those laws. Some people might argue otherwise, which is why we just separate them now. And whether you're exempt or not exempt, if we're doing your notices, we're going to do a notice to pay and a separate notice to quit. The 3-day notice to pay, unless your lease requires more than 3 days, the 3 days have to be business days. So it doesn't include weekends or holidays. And then the notice to quit is also a 3-day notice and also does not include weekends or holidays during the calculation of those days. So the whole time that it takes to terminate a tenancy, if you act quickly, is approximately 8. I think it's 8 days, because you have to add in 4 days. It's 6 days and it's 10. So it's 6 days and then you have to add in 4 days. Also, the first day, I should have done this calculation before I started talking. So the first day that you serve the notice does not count. So then let's say the next 3 days are business days, and then you add 2 more days. So now we're at 6 days, because maybe there's a weekend. And then you would serve the notice to quit. Day 1 doesn't count, so that's 7 days. And then you've got 3 more days, that's 10 days. And then you can terminate the tenancy. Okay, maybe there's one of my staff is on here one of my paralegals might be able to correct me if I'm wrong, but it's about 10 days to serve both notices if you do them back to back with no extra days in between. All right, so, oh, and then the last question, I love this one. What are our fees to prepare the 3-day notice? Just real quick, we have a 3-phase retainer agreement where phase 1 is a deposit. Everything is done on an hourly basis. Phase 1 deposit is $1,500, and phase 1 is where we're doing all the notices that you need, bringing the lease into compliance, doing our whole review relating to whether the property is exempt or not exempt, in compliance, and then drafting the notices, having them served. $1,500 is an estimate. A lot of cases, we can do all this work for less than that. Some require more work than expected and more notices than expected. Phase 2 is where we file a lawsuit. And then phase 3 is the trial phase. But that phase 1 for notices is a $1,500 deposit. And then, but the actual cost is based on the hourly cost of what we have to do. All right. So then the next question also has to do with, wait, I think that was the last one. Okay. Let's see. Hold on, somehow. Oh, I'm going the wrong way. Sorry. I don't know how to use this Canva. Tenant non-payment issues and solutions. That's the one that we just did. And now we are on tenant fraud and illegal subleasing. Okay. The question is, a tenant claims she owns the rental house just a month after moving in. She even showed loan documents to her friends during a housewarming party. The landlord found out this problem from one of the tenant's friends who subleases the house from this new tenant without permission. How do I deal with this situation as a landlord? This is a problem. I mean, it's funny enough that somebody would move in and then claim to be the owner of the property, but you got to wonder why they think they're the owner. And I would predict based on this scenario that this person is going to be a problem. So first and foremost, we'd have to look at the lease and assume that the lease does not allow for subleasing because most residential leases do not allow the tenant to sublease. So assuming that subleasing is not authorized, that may be a good reason to terminate the tenancy. And if that's the reason that you use to terminate a tenancy, there is no option. You can tell the tenant that they are not allowed to cure. The law doesn't require the landlord to give the tenant the right to cure if the landlord can prove that the tenant is illegally subleasing the property. So as long as you have the evidence that they're subleasing, like you have the person you talk to and you can subpoena them to come into court and explain that they were subleasing from the tenant, you've got the eviction. It will work as long as you can prove it. So that might be the first, what do I do? Well, you should probably terminate the tenancy because this tenant sounds like they're going to be a problem. The second issue is fraud. If they're telling people that they're the owner, they're acting like they're the owner, they showed somebody loan documents that are clearly forgeries and fraud, you should also make sure to check your title because if they're committing fraud all of these ways, they may be trying to record fraudulent documents against your title and cloud your title, which will cause you more problems in the future. So you want to catch that as soon as possible. Other questions that I ask when I hear this scenario is this new tenant related to you? Because if they're claiming that they're an owner, they're either crazy or they feel like they have a reasonable basis to say they're an owner. That often happens when a relative, a child, a brother or sister is the tenant, and they believe that they have received an ownership interest in the property through the family estate. So a parent has died, they believe that as a beneficiary of a trust that they should be an owner. Maybe the trust has been administrated, maybe it hasn't. The ownership interest may be unresolved, but that can cause these kind of claims. And then another issue to be aware of are things like adverse possession and equitable ownership interests. When somebody claims that they are an owner and they're not crazy, they have usually been paying the mortgage directly to the mortgage company, paying the property taxes, and doing a bunch of things that make it seem like they are an owner. And this kind of scenario would come along with a lot of facts, conversations, written agreements, emails, text messages that might support the ownership interest or it might defeat the ownership interest. So we would take a close look at a lot of the facts if there is a chance that this individual has somehow purchased an ownership interest in the property that may or may not be documented. So California law requires that an agreement relating to real estate must be in writing to be enforceable, but there's a bunch of exceptions to that, such as promissory estoppel, equitable ownership interest, and something called adverse possession. I'm not going to go through all of these. These are big legal issues that come into play with a lot of our civil litigation cases. They're very interesting, and if you think you have something along these lines, let us know. Checking title is something I do in almost every single legal strategy session that I do. I pull up the property title, I make sure that I can see who's on title and confirm what's going on with title. So we do a lot of that. So title protection is something that we help with. All right, so then next question. Actually, there were a couple of follow-up questions to that last one. Can she sell my house? My response is not without committing fraud. And what precautions should you take? The answer to that is check your title and make sure she's not committing fraud on your title. All right, next question I'm curious about how to properly move three people who are each currently on individual leases and all live in the same property onto one lease. Are there any legal ramifications for doing so, positive or negative? So these are three people who are essentially roommates, but they've been given individual leases, and landlord would like to now have them all on one lease, if that makes sense. Once those leases go month to month, the landlord can present the tenants with a single lease that has all three of them on it, but the tenants don't have to sign it. So that would be a contract novation. If they all sign the new agreement, then ta-da, it's done. That's all you need to do is get them to sign it. This is also a convenient moment to bring the lease into compliance if it's out of compliance. And so, before you go presenting them with the new lease, you should definitely have an attorney confirm that your lease is in compliance. When we see these scenarios where there are three people living at the property that are on separate leases, or even more complicated when they're all on the same lease and somebody leaves, there's a interesting legal issue of possession versus the rental agreement. So let's say you get them all on one lease and it's a 1-year term, and one of the three people leaves early and doesn't want to pay the rent anymore. The other two tenants keep paying their portion of the rent, as they always have, and all of a sudden you're not getting a third of your rent. What is your legal recourse? So, and this is one of the legal ramifications of putting them all on one lease. Once they've signed all the same lease, they're all equally responsible for the whole amount, jointly and severally. That's one of the terms that we use. So under the contract, you can hold all three of them accountable for the full amount of the rent. You can take this one who left to court. You can take all three of them to court. You can get a judgment for the unpaid rent. You can also evict the remaining tenants for non-payment of rent if you're not getting the full amount on the single lease. But when you have three separate leases and one of them leaves, you can only hold each of them accountable for the amount of rent that they've agreed to on their lease. So then when one of them leaves, even if they're terminating it early, you can only go after that one for the amount that that one owes. If you get them all on the same lease, then you can pursue them all for the whole amount. So possession does not necessarily, just because one moves out, that doesn't necessarily terminate their obligation to pay. But it does take away your right to evict them, because you can't evict somebody who has already moved out. It's the legal issue of unlawful detainer. If they've moved, they're no longer unlawfully detaining the property, so you can't take them to unlawful detainer court. You have to take them to either small claims or civil court. The security deposit can get complicated if somebody moves out and you've got them all on one lease and they've all got one collective security deposit. This is an issue that the tenants have to resolve between themselves. The landlord is holding the deposit in trust for all of them. And if one leaves and they want their portion of the security deposit, the other two tenants may want to pay that person for their portion. They don't have to, but it's really not the landlord's problem. The landlord is not obligated to process the security deposit if they're all on one lease. That's different if they're on separate leases, but if they're all on one, the landlord is only obligated to process the security deposit per Civil Code Section 1950.5 once the property is vacant. Now, with separate leases as roommates, then I would recommend that if one leaves, then you process their separate security deposit pursuant to 1950.5 within 21 days. Okay. There are some interesting eviction issues that come up too if you're trying to evict just one out of three people. So one of them stops paying and they stay, and you just need to get that one person out. We can evict just the one person and not the other two. But when the sheriff goes out there, it creates some interesting circumstances that we have to manage at that point in the eviction if it becomes necessary. All right, then early lease termination. So the question is, if a tenant wants to or needs to exit their lease early, what would be the best way for a property owner to handle such a situation? And what can they charge a tenant for in such an event? So if the tenant wants to terminate their lease early, I usually recommend a buyout so the tenant can buy their way out of the lease in order to avoid future legal issues with the landlord. That would be the first approach. If a buyout agreement does not take place, then the landlord has to mitigate their damages. So the landlord has to advertise the property for rent at fair market value, and it's called on the tenant's account. So the tenant has a 1-year lease, they leave after 6 months, their account goes on for 6 more months. The landlord has to mitigate damages by re-renting for the next 6 months, or at least making a reasonable effort to re-rent. And the landlord may have to prove that they mitigated their damages by advertising the property for rent and trying to re-rent it and considering qualified tenants that submitted applications. They can also accept applications of people who were recommended by the tenant. And if they fail to do so, if they fail to take these steps, then they may not be able to recover anything from the tenant for the loss of rent during the time when they were unable to find a new tenant. But they can collect from the tenant that moved out the cost of re-renting the property and the loss of rent, as long as they can show that they did their job of mitigating the damages. The security deposit, I usually just recommend, if you know the tenant has left, go ahead and process the security deposit within 21 days, but you don't have to. You can wait until the property is re-rented to process the security deposit. And if you don't re-rent the property, if you for some reason cannot re-rent it, you only have to process the security deposit after the lease comes to an end. So the basic rule is when they vacate, you process the security deposit within 21 days, but there is an exception. I don't recommend messing around with the exception. Just do it within the 21 days. Don't worry about it. Okay. So that's all the questions. I will check the chat in a minute. I wanted to let everybody know that in January, we'll do our new laws webinar. I didn't have a chance to update everything. It's been a busy couple of months, but so I'm not doing new laws before the end of the year. I'm going to do it in January. So our January webinar is going to be really awesome. I wanted to put this out there because my associate attorney, Kush Nagin, let me know, and I was surprised to find out that air conditioning is being added as of January 1st as a habitability issue. So if you do have an air conditioner at your property and the property is rented as air conditioned, you need to make sure that the air conditioning is working. And there may be other concerns with that, but we'll have an update on that in January. All right, thank you all so much. I'm going to look at the chat now and see if there are any more questions here. And here's our contact information, so feel free to reach out or email us. Okay, so let's see, I've got a few questions here. On the structural accommodation, isn't the tenant required to change back the property when they leave if requested? Yes. Yeah, that's my understanding. So we're going back to the reasonable accommodation discussion. If the landlord makes a reasonable accommodation by allowing the tenant to make the structural changes at their own expense, the landlord can also require the tenant to remove those changes when they move out at their expense, at the tenant's expense. All right. Next question, is title theft a real problem or just hype to sell insurance? I mean, what's the definition of a real problem? In my practice, we see title transfers that occur and the owner is not aware of it. We see title fraud. We see forged signatures that are notarized. I currently have a case where the forged signatures were notarized by a forged notary. I mean, that's what they're alleging. This case is in litigation, and the notary is saying that their signature and their stamp was forged. So, yeah, it's a problem. And for that case in particular, the property was sold to a buyer, and the buyer is this nationwide buyer, and they said this is happening to them in various states. That, there's a fraudulent seller that sells the property right out from under the owners, who find out after the fact that the title was transferred. And then we have to undo that, usually by quiet title action, to get a judgment quieting title. Next question. San Diego County has a notice program for anything recorded against your property. Yes, that's true. Thank you. You can sign up for a program that will send you notice if your title changes, and that's a really nice thing to do. Hypothetically, of course, I have a tenant who rents out my unit in a condo. He's been present for nearly 10 years. The relationship is cordial. He's on a month-to-month lease. I'd like to get out of the landlord business and ready the unit for sale. If I understand correctly, I can bring the lease into compliance and then ask him to leave without providing relocation assistance, noting that the unit will require substantial upgrades prior to sale. Is that correct? So if it's a condo, then the property may be exempt. And once you bring the lease into compliance, you should claim the exemption so that you do not have to pay relocation assistance. And you also technically don't have to comply with any just cause reason to terminate the tenancy, but we would still recommend it. And in this case, you've mentioned two. One is that you want to sell the property, and the other is that you want to do a substantial remodel. I would recommend withdrawing the property from the residential rental market to sell it as your reason, because that one's a lot easier than promising that the reason is a substantial remodel. If you're going to use that reason, then essentially you have to go through with a substantial remodel, and it's just a more complicated scenario. But you could use either one. If you're exempt, saying that you're going to do a substantial remodel doesn't necessarily require you to comply with getting the permits and having it be unavailable for 30 days. But if the tenant hires an attorney, they might raise that as a defense, and then we would have to litigate that issue and hope that the judge rules in our favor that as an exempt landlord, you do not have to get the permits or have it be unavailable for 30 days. Okay, so how do you get a tenant out on time with a less than 12-month term? I do summer vacation rentals and need the tenant out on their termination day to avoid cancellations, refunds, and suspension of my vacation rental listings, which would ruin my business. Oh, this is okay. This is a good question. We can issue notices prior to the termination of the 12-month tenancy as long as it's in compliance. If the lease is not in compliance and you've got a 12-month term, we can't bring it into compliance until after the term expires. So that causes some delay because we'd have to do a 30-day notice after the 12 months. Actually, we do a 30-day notice prior to the end of the 12 months, and then we would do a notice to terminate. But if you are in compliance, you can issue the notice to terminate. Like if it's an 11-month lease, you can do a 30-day notice 30 days prior to the last day of the lease. So that's the best way to set it up for success. We cannot guarantee that the tenant will move out at any time. But if the tenant does not move out and you lose business, you may be able to pursue the tenant for damages for breach of contract because you lost business due to their breach. Okay, let's see. Are month-to-month leases still a reality in San Diego? It seems like the new ordinance negates the ability to have the tenant leave on 30 days notice. You can still do a month to month lease, you can do it. I'm not sure if you mean a short-term vacation rental, which you'd have to have a permit in the city of San Diego for that. But you can do up to a 3-month lease and not have to comply with the city of San Diego ordinance. I recommend if you want to do a month-to-month lease, just do a month-to-month lease, and depending on whether the property may be exempt, make sure you're in compliance. If you can claim the exemption, make sure you do that. If you can't, I think it's nearly impossible to try to do 3-month leases just to avoid the ordinance, but I've seen people doing that. So you just do 3-month leases over and over again. But yeah, absolutely, you can do a month-to-month lease. Getting somebody out with a 30-day notice depends on how long they've been there, and also, we can't guarantee that they move out just because you asked them to. So hopefully that answers your question. I'm not sure that I got that one right. Anyway, thank you all so much. It's after 1, and I really appreciate you all for attending. I'll see you in January, I hope.